6-537. It looks like we've got two there. Paul, are you going to present, or Peter, do you want to?
Yes. Given the findings that the commission made on item number E5, I think it was, or regarding the grading issue, and since we typically will rely on the commission's findings on issues and use that as precedent for future action, we do not have any evidence of actual grading on this one. So given that fact, we are prepared to rescind the denial on this this application and just would request it be taken off the agenda.
Do you have anything to say about that? Do you want that done?
Yeah, let's do that. I have pictures that there wasn't grading, so.
You have to get up to the mic. You have to get up to the mic, please.
So we're talking about 537, correct?
537, yes.
Okay.
And
Yeah, I have
545?
pictures here with me that there
Separate
wasn't grading.
Okay.
Is this the one where there was?
No, it's the next one. No, next one.
There
Yeah,
was
brushing.
brushing, they expanded the cultivation, there was brushing that was done, but there was no evidence that actual grading, movement of earth occurred
Under the county
un-
definition of grading.
under the county's definition, well, under the interpretation of the urgency ordinance as it applied to earth moving and grading for the purpose of cultivation.
Well, I got a question about that. His application was for 4,000 square feet. The pictures seem to show that in 2016, the cultivation area was 4,000 square feet. And it says 2017 cultivation area is 2,800 square feet. In addition, that's figure 5, the aerial of 5/31/2016. Why is it that the applicant is permitted to grow apparently 6,800 square feet when his registration is for 4,000?
Do you,
I'm not, I don't have all that information, well, I wasn't looking at that specific issue. Our denial was based on grading.
We would have to show grading for that expansion.
Well, and
No.
if he grew more than what was allowed,
Yes.
we would have to notify him that he was over canopy. He would have 24 hours to remove that canopy, and if he didn't, he would then be in violation.
Well, now, that's though if you're growing over canopy as of the time you did your registration. This is a case in which he registered for 4,000, he had 4,000, he wasn't over canopy. Then he went over canopy.
I thought,
Yeah,
what Peter said would then cut in.
Well, I'm not
Do
so
you
sure
have the
that it would. I
application
mean,
with
if
you, and can you
if
verify
you
the
register for
application?
20, if you register for 4,000 square feet
recall?
and you grow 4,000 square feet, and then you go and just cultivate another 4,000,
It
I
was
think
for
you're just
4,000.
automatically in violation of the ordinance.
okay, so,
Period.
okay, hold on one second. Let's get a grip on this. So Paul is verifying that the application is 4,000 square feet. So the grow is 6,800. That isn't something the commission would technically look at? That's something where a notice of violation would be issued and he'd have 24 hours to remove? Is that what I'm understanding?
Yeah, that's been the way we've dealt with it. I mean, I can actually recall a hearing in which there was a caregiver grow site that registered for 400 feet. They had, I forgot what it was,
Yeah, it was like
2,400,
12,000.
12,000, that what it was? And it was actually you, Commissioner Wooster, who agreed with the lawyer, who happened to be Ashley Bargenquist at the time, that we needed to give her notice and allow her an opportunity to fix. And the commission ended up denying it because it was false and misleading evidence to
Correct.
submit an application as a caregiver and grow a commercial grow. But I think even at that hearing, it was you, Commissioner Wooster, who said that she had an opportunity to fix within 24 hours notice.
That's right. That was a lady, though, who was growing excess canopy at the time she registered. This is an application in which that didn't happen. The intent of that provision was if you were growing excess canopy at the time you registered over what you applied for, then the 24-hour notice provision applied. This is not that case. This is a case in which it became over canopy afterwards. And
Okay,
so
I
what
need
you do,
to-
what happens
you
You
guys
is,
know
are
what, I need to
saying
bring this
it's
back.
over
Hold on one second, you guys, because we're going to get a little bit carried away here. So Peter has made a recommendation to dismiss this case. I want to run this past the commission and poll them as to whether or not they want to have this hearing. So, let's poll the commission and find out if you want to have the hearing, just as if though we were asking for a continuance here. Is that okay with you?
So, but I think maybe before we do that, we need to address Commissioner Wooster's concern, and the issue is, one, the only reason for denial was grading.
Okay.
That's the only stated reason for denial. 165J reads, if the maximum amount of cannabis cultivated exceeds the maximum total canopy area permitted in the cultivation site's zone or the provisions of this chapter, the total canopy size shall be reduced to conform with the requirements of the zone and this chapter within 24 hours of receiving the registration or of notification by an enforcement official. All excess cannabis shall be immediately destroyed with none retained for use of the registrant, landowner, or for transfer to any other person or entity. And that was, as I recall, what Ethan stated, was that we had a similar situation. We said, well, they're denied outright because they were growing over canopy. And I remember Commissioner Wooster, you stating clearly, and can't remember if it was the full commission or you know, and I think you're right that it was denied on other grounds, but that was not a grounds for denial, was that they needed to be provided the opportunity to come into compliance. He had 24 hours to come into compliance. At this point in time, we haven't notified him that he was over canopy.
I appreciate, Commissioner Wooster, do you see in that language something that restricts that remedy to time of the registration?
yes, this J section is under the, I gotta find it, but
Okay, so just because procedurally, I don't want to mess things up here, I want to say that we're having a discussion whether or not we want to dismiss so that we can have the discussion. I don't want to just say that we're addressing someone's issue without having an open hearing of some sort. So right now, my hearing is that we're discussing whether or not we want to dismiss.
correct.
Okay, just be clear.
Well, if the planning director's recommendation is to, I suppose, grant this appeal,
Well, it would be withdraw our denial.
okay, withdraw your denial.
And we may come back on other grounds. And we have to look at those,
Code compliance could give the notice of over canopy tomorrow.
right.
Okay, I'm all right, I'm okay with that.
Okay.
Okay, so
Does he need our permission?
I just want to take a vote here and make sure that we are dismissing per the commissioners or not.
No, he's withdrawing, that's true.
He's withdrawing his,
You're withdrawing.
He's showing up without evidence.
he's withdrawing his denial.
Okay,
Which leaves other remedies open. But thank you, Commissioner Wooster. I wouldn't have spotted that overreach.
okay, so we are, let me just get my head straight. We are withdrawing the appeal for 2016 dash, make sure I have the right one in my hand, 537?
Yeah.
Okay. Done. Now we are going to move on to item number 82016-545. And okay. Paul. So, Mr. Houghton, he is going to, did I say that correctly, I hope? He is going to do his 15-minute presentation. You're welcome to have a seat till he's done, then we're going to call on you to do your 15-minute presentation. Thank you. Sorry for the confusion on that. It should be, you just won.
All right, this is Appeal 2016-545. Kern Houghton, how do you say your name, sir? Houghton.
Houghton, I said Houghton.
Okay. Mr. Houghton is appealing the Planning Director's denial of medical cannabis cultivation registration application 2016-545. This is a 20.64 acre site. It's located at 1280 Doe Road, Colony Hill, and that's in Township 5 North, Range 13 East, Section 10. On June 28th, the applicant, Mr. Houghton, filed a commercial cannabis cultivation registration for 10,000 square feet of outdoor cultivation area. This denial is based upon the appellant's failure to meet the requirements of Section 1795-165N4, and that reads as follows. The registrant must demonstrate compliance with the Central Valley Regional Water Quality Control Board regulations by providing documentary evidence satisfactory to the planning director of either of the following. A copy of a notice of applicability enrolling the cultivator for coverage under General Order Number R5-2015-0113, consistent with the area proposed for cultivation. Or B, a copy of a notice of intent to enroll the cultivator for coverage under General Order Number R5-2015-0113, consistent with the area proposed for cultivation. If the registrant has not filed a notice of intent with the Water Quality Control Board prior to submittal of the registration to the county, the registrant shall submit all necessary forms and documents to the Water Quality Control Board to constitute a complete application for that agency's purposes no later than September 7th, 2016, and provide a copy of a document indicating receipt by the Water Quality Control Board to the Planning Department. So, on September 1st, 2016, the appellant submitted a notice of intent for a Tier 1 coverage to the Water Quality Control Board. Based upon the size of the project, the Water Quality Control Board determined the registrant's Tier 1 selection on the NOI was incorrect. On November 3rd of 2016, the Water Quality Control Board mailed an incomplete notice of intent to the registrant. The notice informed the registrant the tier selected was incorrect and therefore the NOI was incomplete. It instructed the registrant to resubmit the NOI for the correct tier size. On July 11th, 2017, the Water Quality Control Board issued a second notice of incomplete notice of intent. That notice informed the registrant that the NOI remained incomplete and instructed him to respond within 30 days, 30 calendar days. On September 5th, 2017, staff verified with the Water Quality Control Board that the appellant had not responded to the second notice with the required NOI. The appellant had failed to submit a complete application pursuant to 1795-165N4, and for that reason, the application for registration was denied on September 7th, 2017. Subsequent to that, the Planning Department has been informed by the Water Quality Control Board. The appellant did submit the required NOI on September 20th.
September 20th of 2017? Okay.
Yes, it came after the denial. On September 22nd, Mr. Houghton filed an appeal of the denial. In the letter of appeal, the appellant does not explain why the requested NOI for tier modification was not submitted to the board after their initial request or promptly after the second notice. One thing that wasn't included in the staff report, and I want to, is this letter that was sent to our office on September 17th. I want to hand this out. I had, let me hand this out.
Can you make sure that the appellant has one as well? Thank you.
I believe I've already given him one.
Yes, sir.
This letter was mailed to the planning department after the denial. I had tried contacting Mr. Houghton to confirm that this was actually pertinent to this appeal. It actually identifies the site as another registration he has over on Cedar Way in Mountain Ranch. But these comments are in response to the denial he received on this application, 2016545. And I'm just going to read this into the record. It says, I expect that my denial regarding cannabis cultivation registration will be rescinded. The supplemental documents were submitted in full before September 7th, 2016. I did not know that the tier size was incorrect or needed to be adjusted because I did not receive notification to do so. A report was completed and submitted to your office prior to September 7th, 2016 by Natural Investigation Company. Enclosed, please find a recent calculation site report from Natural Investigations Company on September 14th, 2017, along with the Central Valley Regional Water Quality Control Board notice of intent and payment sent on September 18th, 2017. The supplemental documents were submitted in full before September 7th, 2016. We don't have anything that actually shows that that is actually what happened. States
Do
I
you know
did
what
not.
the supplemental documents were, what he's referring to?
I would believe the supplemental documents would apply to the biological site
I see,
assessment.
yeah.
That's what I would think. I did not know that the tier size was incorrect or needed to be adjusted because I did not receive notification to do so. We know that the water board sent him notification. A report was completed and submitted to your office prior to September 7th, 2016 by Natural Investigation Company. That is correct. I found that. That was actually submitted. It was a tier assessment by Natural Investigation Company assessing the tier as Tier 1, okay? So he went and had somebody actually assess the site and assess it as a Tier 1 site. And then the water board determined differently. Enclosed, please find a recent calculation site report from National Investigations Company on September 14th, 2017, along with Central Valley Regional Water Quality Control Board notice of intent and payment sent on September 18th, 2017. I went back through the file and I could not find that. But I wanted to make sure this was put before you. Like I said, it was from Mr. Houghton, but it identified the project as his other parcel, although I believe these comments are pertinent to this appeal right here.
Okay. Anybody have any questions of Paul, or do you want to hear from Mr. Houghton?
I have no question.
No questions.
Okay, so you can come on up. Just for clarity purposes, this letter that he just gave us, it's from Kern. Is your name with a T or without a T?
It's with the T.
Okay, so I just want to make sure that our paperwork is correct and the letter that is from you is wrong.
Yeah, that my name's not spelled right, and the address should be for Doe Road in the parcel number of Doe Road.
It's a different parcel?
Yeah, I mean, this is a letter to the planning department that has the wrong. It's from me with my name without the T, and then I should have put the parcel number for Doe Road and the address for Doe Road.
Okay.
It's just the wrong address.
Is this referencing a different grow?
Yes, my other grow.
Okay, so I just wanted for clarity purposes. This letter is for the appeal that we are working on, not for a different one. It's just the APN.
There is no appeal on Cedar Way.
So this is just the wrong address, and we
Yes.
can correct your letter for
Yes,
you,
thank
and
you.
we're good.
Yeah.
Okay.
The information in the letter is, we're gonna talk about that, I guess.
All right, we're ready. Sorry for
Please speak
interrupting.
up just a little
Okay,
bit.
yeah, I'd like to just thank you guys for having so much communication with each other, because it's amazing. And I have all the national investigation stuff that I turned in late, and I didn't receive the notice to do so, to get this stuff done.
Did you bring copies that you wanted to distribute to us? Thank you.
So you didn't receive either notice, the one that was dated the 3rd of November 2016 or July 11th,
No.
2017?
Now, that one is addressed to you as Nucleus Farms,
And
which
that-
is the address that you put on your letter to the planning department.
Yeah,
But as I understand, what you're saying is Nucleus Farms is not the subject of this particular,
no, it
Appeal.
is the subject.
oh, it is?
Yeah, it's just a
Okay.
different address.
So, so then, are you saying then that these, I understood that you were saying that you did not get the notices from the Water Board of 3 December 2016 and 11 July
Yeah,
2017?
those two notices I did not receive.
You did not receive either one of those?
Received those, yes. So,
That is the mailing address you have on your application also though, correct?
the 2700 Railroad Flat Road, yes.
So I know, so did I, and so did they. So you and I are going to have to, let's give this to them, and then we'll share his. You can look at his. Okay, so you know what I want to do? I want to get back on track, because it seems like we're interrupting your 15-minute program here.
Oh, really? Okay, great.
So you get
Yeah.
15 minutes to do your presentation, and then we grill
Then we
you.
ask you.
Okay, yeah.
Okay.
So, what's wrong here is my letter to the planning department. It's the wrong address, wrong farm. The farm that should be on this letter to the planning department would be the one on Doe Road, 025, I believe is the APN number. And,
025-028-025. Okay, got it.
yeah. So what we just rescinded earlier, that denial I got word of, and I came into the planning department, and I found out also about this denial like a week before. And I was amazed because I didn't know that I had to do a tier adjustment, because I had the investigator out, the natural investigator, and he had put my tier at tier 1 already. So, and I had that information. I thought it was correct, and I hadn't got any other word by mail to change the tier. And so as soon as I got word in the planning department that I should have done that, and that was before they denied it. I was in the planning department for Sierra Madre grow, and that was before they denied the Doe Road. So I called up natural investigators and made an appointment, and got the next appointment. It took a week or so for them to come out and had them do their assessment. It took them a couple days to go back to the office and make sure the assessment was correct, and then I filled out all the paperwork, got it in on a Monday, and paid for it, and that's what I handed you guys. So the paperwork is late, and I don't know. Yeah, I didn't receive mail very easily from that address, because it was where my house had burned down and my dad's arm had been cut off during that month in November.
So my understanding is that, well, when did you first become aware of the Water Board's letters of 3 November 2016 and July?
It was
11th.
the first week of September when my the denial of Sierra Madre had been denied. And I went into the planning department and I asked them, well, what's going on with my other sites? And they said, oh, well, you haven't done this.
And yet the planning department itself received these letters. Yeah, I mean, apparently there were.
I didn't get any emails, I didn't get any calls, I got nothing. Supposedly 2 things came in the mail, and honestly, I don't have those letters. My dad was in the hospital for 2 months, almost dying, got his arm amputated 5 times. In July, my son was on break. I don't know. Honestly, that mail-in address is somewhere where I don't like to go anymore. It's where my home burnt. I grew up there. It's kind of sad for me. I don't receive the mail there. It got lost in the mail. I don't know if it even showed up there.
I just need a little bit of clarification. First is Natural Investigations, you called them, they came out to certify whether you were Tier 1 or Tier 2, correct?
First, I had them come out and they gave me an assessment at Tier 1, and I
Okay.
turned that in, and that's what I thought. That's why I thought all my paper was complete.
Okay,
But I guess the water board had determined it wasn't correct, and they sent me a letter I never received. And then when I got notice of the denial of Sierra Madre, I went into the planning department to see what was going on, and I asked about my other parcels, and they said, well, we also haven't had this tier assessment adjusted correctly.
okay.
So I got right on it, and I started doing it, calling up the Natural Investigations, and in the meantime, they denied me that same week. And by
Okay.
the following week, I had the paperwork that I handed you guys.
Natural Investigations did this report that's in our hand, and it was turned into, your name is spelled different again.
Where?
On the Natural Investigations. Not only that, but the addresses or APN number is wrong that was submitted to your notice of intent, the NOI address.
Well, I got an assessment on all 3 parcels, so you might be seeing the other parcels.
No, I'm looking at your copy to submitted, your NOI submitted, changing it to a Tier 2. Your assessor's parcel number is wrong on that as well. So, okay.
I guess I'd have to look at that. I don't know what you're
Yeah,
talking
you've got a lot of issues with spellings of names and addresses and APNs and mass confusion. Okay, so you took this and you filed it with the water board.
Yeah.
They've accepted your Tier 2. Did they give you a letter of acceptance?
I'm not sure. I sent them in the checks and stuff. I haven't received anything yet. I don't know.
Okay, so have they cashed your check?
I don't know.
Okay. Do we have any proof for the planning department, the commission, anybody that Tier 2 level's been accepted and the water board is moving forward? How long ago was this? This was 2 months ago, or a month ago, excuse me. Right?
I'm just waiting to hear from the planning department and the water board of what to do.
Okay.
Yeah.
I'll give you just one quick timeout. Paul, have you received any documentation from the water board?
Yes, on October 4th, Michael Parker at the Water Board sent me a note here. It says, we have received the new NOI and fee for enrollment at the proper tier size. Within the last month, I received them on 20 September 2017 to be exact. His enrollment into the correct tier for this site depends on the appeal decision with the Planning Commission. That's from Mr. Parker.
Goes back and forth, doesn't it?
Yeah.
On
this
the
was-
application that you sent them, this last one that you sent,
Uh-huh.
you put the same address. If you're not getting your mail there, how do you expect to get a letter back from them the 3rd time?
Well, now that I know there's important mail coming, I'm going to be more on top of it and making sure that my father understands how important it is to me.
Okay, so the letter,
And I wouldn't know what other address to put actually too, because I only have that address.
you're using Cedar Way, you're using 2700 Railroad Flat with the water board and with the county.
My mailing address is 2700. I'm trying to keep one address for mailing, and then all the other addresses are physical addresses.
Okay, and when you filed your original NOI under Tier 1, what address did you use there, and where would they have tried to contact you? 2700 Railroad Flat. Is that the address you're getting your mail?
Yes, I would think so, unless they send it to an address that's a physical address that I don't receive mail at. Maybe that's what happened.
Okay.
I don't
Do
think
you
you-
get physical mail at 2700 Railroad Flat, or do you have a P.O. box?
Physically.
You physically get mail?
And as far as you know, for this grow, you have never supplied another address to the water board.
True.
Okay. So the really,
Both notices from the water board were sent to 2700
Right.
Railroad Flat Road.
And then you just wrote us a current, brand-new letter
Yes.
with Cedar.
True.
Are you just trying to confuse us on purpose?
No, I'm confused. I'm really confused. I'm confused too. I don't understand.
Okay.
I didn't mean to do that.
No, it's fine. I just want to make
Yeah.
sure that we understand maybe why you didn't get your mail. We're trying to,
I believe that in November, I was in the hospital for like almost 2 months with my dad almost dying. I mean, he had
okay.
5
And then,
different amputations of his arm.
and then your second
And
notice?
the second notice, I don't know. I don't know if I went on a camping trip with my son during his summer break, and my dad has one arm now, and he reaches to get the mail. It's not his dominant arm. I don't know if he dropped it. I don't know if it's in with all his other important mail and didn't get put off to the side. I just
Did-
didn't receive it. So as soon as I got word that I needed to do it, I went and got it done. And at that same time, they denied me. So
Okay.
that's why I'm here.
I'd ask for public comment, but there isn't anybody behind him, so.
maybe you better ask just in case.
I'm going to ask, and look, do you have any new information you want to give us right now before I go ask him for any rebuttal? And then
Just
we'll,
as long as you guys understand the information that's been given is incorrect as far as that one address. And
we got that.
That's it, simple. Okay.
Okay. So,
I guess I don't understand this. Can I ask a question?
absolutely.
Do you have a grow on assessor's parcel 20-27-53, also known as Cedar Way?
Yes,
Okay. And that's different than the grow that is at 1280 Doe Road, is that correct?
yes.
Okay. Now, what I'm looking at here with this Natural Investigations Company report of September 14th of this year, and the NOI, it refers to the 20-27-053 Cedar Way Grow. That's what it says. Got that?
I gave you 3 papers, bundles of paper, and there's one for Cedar Way, one for Doe Road, and one for Sierra Madre. So there's 3 parcel numbers with 3 different grows,
I
with
have
3
Doe.
different,
Oh, we only have
What
one
do you
copy
have?
of each.
one copy of each site.
We have Cedar.
I'm sorry for the
They look the same,
confusion.
and we just passed
They
it.
look the same.
Now we get why, oh, thank you.
This is Sierra Madre.
Okay, we have
think we
Cedar,
wanna
or
see
Doe, we have Doe.
Okay,
We
those
have
are the
the-
one where,
Doe has been certified as Tier 2.
let's start at the very beginning.
Let's start at the
Doe.
beginning now.
Okay.
You gave us 3, thank you, we got it.
That's-
We're with
you
you
do-
now,
okay.
mentally. We're sorry that we were
I'm
confused.
confused. I was confused. My name is spelled wrong, and then the address. So
Okay,
okay.
You guys want to see?
no, are you going to certify it's the Tier 2? We've got the right one, I think. We only care about Doe. Doe is certified Tier 2 by this company now. Okay,
We'll pass this back. This is Sierra Madre. Doesn't-
okay, so these copies, we need to have a copy that is left with,
I left
this is
them
Cedar
on September 20th. I think.
We don't have that.
So we don't
I have
have
not
Cedar
put
Way.
that in our
we need to make copies of this if this is your only copy before we can give it back. We need to have staff have a copy.
Okay.
So
Yeah.
when this is over, can you guys make a copy and give,
I would love to take all of that back to our office.
make sure you put the right one in the right file, though.
I'm going
Let's-
to copy all of it.
You're going
Okay.
to copy all of them, okay.
Yeah, we have those covered.
Okay,
I handed those to somebody in the department too. So-
okay, let's not even go there right now. We don't need any more. Let's just
Here's
keep
Doe.
going forward. We got what we need here for the moment.
Just for the record,
Do I take it
I'm
back?
not entirely sure we want to turn over 2 of the 3 sets.
Well, Paul wants all 3 sets in all 3
All
files.
okay, good.
So that's Paul. He submitted them. Paul needs them. I'm
Okay.
staying out of
I
that.
thought we were turning back.
No, I'm not going backwards.
Sierra Madre and,
Yeah.
Wow, that was.
So if I had this is the summary of what I understand. You say the facts are, okay?
Okay,
And that is that you submitted your first application with the documents and the payment and everything else before September 7th.
Yes.
You didn't know there was anything wrong with that until your other parcel was denied and you went in and talked with the planning department.
yes, sir.
And that's when you found out that these other Water Quality Control Board notices had been sent. Those may well have been received at the proper address that they were addressed to, but you never have seen them, and something must have happened to them, or maybe they're under the bed or something like that now.
Yeah.
Once you learned from the planning department that the Water Quality Control Board had,
Actually heard, yeah.
yes, heard, issued the notice, then you took steps and had the Tier 2 report finished, which is this one.
Right, had a
for-
reassessment.
For the assessment, and have mailed that in with whatever appropriate check is involved.
Sure.
As far as you know, that's been received. I forgot, do we know that that's
Yeah.
been received?
Yes, that's what the.
Okay.
Well, he says they're ready to roll, basically, with
Yeah.
that email I just read.
Okay. I just wanted to make sure that and am I off with any of that?
I think that's exactly what happened.
Okay.
Well, actually, did that happen on all three parcels?
Oh,
Yes.
I got an assessment for all 3 parcels.
Okay,
But there were two notices for each of the three parcels, and you didn't get any of them. Is that
You know,
right?
there was just one notice as far as I don't even know what the notices are.
Okay.
Except I know there was a denial for Doe Road.
well, one
Okay.
last thing. Do you consider yourself in Railroad Flat and on Doe Road?
Yeah, I mean, I went to Railroad Elementary.
Okay, I'm just curious because we had another one on Doe Road earlier that was identified as McCollum Hill.
Oh, yeah,
Okay,
the
that's-
mailing,
that-
the
I don't
mailing
wanna
address
confuse
is
it
funny
here.
because it's a circle, but
Okay.
okay. I'm looking at your calculations from Natural Investigations Company.
yes.
Okay. And either I'm not reading this right, but what was the size of the application for this particular grow on Doe Road?
10,000,
10,000.
yes.
So if it equals .90 of an acre,
Mhm.
that's a little more than 10,000.
Is that what his calculation is?
That's what they're
for the
assessing
actual
at.
grow?
They have 4 gardens on this parcel,
True.
0.557 of an acre, 0.03 of an acre, 0.17 of an acre, and 0.13 of an acre, totaling .90 of an acre. We only allow a max of 22,000 square feet. Your application is 10,000 square feet.
There's a,
And I'm looking at
from
the.
what I understand, there's a difference between canopy and, that you guys are concerned with. I'm paying you guys per square foot for the canopy, and the water board is measuring the area that I've disturbed. So
Correct
that's the
statement.
difference, that's the discrepancy between,
Okay, so
what
when
I
I
paid
look
for
at
and
this, and there's a line drawn through here, they're counting 1, 2, 3, 4 gardens,
Mhm.
okay? I'm not sure how this our county would register something like that, and you're telling me that's 10,000 square feet?
Well, the canopy would be, yes. And I didn't want to do any grading or clearing of the land because I believe in the ecology growing back, so I didn't cut anything down, and I put it where it was clear through the property.
We ran into that earlier today, where what the water
Yeah, but
board
this is
considers as a
different.
disturbed area or occupied area is different than the canopy.
I understand that.
Yeah, and
But
also with
look at
the
that.
Kelly, the Kellys that were here earlier, I just found out through being here today that in the black and white, you can expand. I didn't know that. So if I would have known that, I would have paid more money and expanded. But I didn't pay any more money, I didn't expand.
We didn't know that till today either. And, but then, I'm not even gonna go there. Okay, so,
Is it
Where are
like this all the time in here?
pardon me?
It's not like this all the time, or?
No.
Okay.
Yeah,
Really?
No. This has been an experience. Okay, so where we're at is, you've done rebuttal, right? Did you rebuttal?
No, ma'am, I have none.
You have none. I don't know if that's proper English.
No,
And-
I
Have
did
not.
not say I didn't have any. I said I have not done it. I have not been
Is that
asked.
what you said? I thought you said I have none.
Oh,
He's trying to emulate Mr. Watts.
Okay, would you,
Alan?
do you have any rebuttal?
Yes, I believe I do. Just to make it perfectly clear, the address that Mr. Houghton provided both on his registration and to the Water Quality Board with his application on the original NOI was the 2700 Railroad Flat Road. And that is where those notices of incomplete NOIs were sent. That's the record, that's the address we still have on record. In regards to the discrepancies here between the City of Way address and then the content relating to Doe Road on this letter right here. I did try to contact Mr. Houghton a number of times before I wrote the staff report. I was trying to contact him through the telephone number he actually supplies us on his application also. I called twice on October 5th, twice on October 6th, once on October 10th to clarify this. I was trying to get this information straightened into the staff report. Unfortunately, he has a mailbox at school and doesn't take any messages. So we have an address that doesn't work. We have a phone number that doesn't work. I also sent a couple of emails to Mr. Humphrey.
And the emails
In
I-
regards
The
to...
emails I received.
And those he did receive. But those were not necessarily on this subject, but it was in terms of regarding a continuance. Could we possibly continue his appeals? And those went unresponded to. So we are having some communication problems here. I believe the water board provided notice to where they were supposed to. If he doesn't go and pick up his mail, that's not the water board's fault. It's not it has nothing to do with the responsibility on the part of the planning department. And I would request that he update us with a proper phone number, proper mailing address that works.
That's in the ordinance.
Well, I know it's in the ordinance. It's understood.
Okay.
So that as an excuse really doesn't wash with me.
Okay, and you get a chance to rebuttal what he just said.
Yeah, a proper address and phone is hard for me to acquire, especially when I registered. It was right after I lost my home from the Butte fire I grew up in and I built and my son was born in, and it was just chaotic for me. And so I registered the address I'd grown up on, but I was not living there. So I'm not going there to pick up my mail. And like I said before, my father's arm was cut off and he's picking up the mail. And it's not his dominant arm, and I'm not making excuses for my dad not dropping. I mean, my dad probably, I don't know what happened to what was sent to that address. I guess I would like to get a mailbox at where I'm living now, but there is a big, huge bridge construction, and there's no place to have a mailbox there right now. They're not allowing that.
I would suggest that if we were to grant this appeal, that you better
Could it
take
be
steps so that you know that mail sent to 2700 Doe Road is going to be received by you, because these are very, very important.
Yeah, I think I should get
Notices.
a change of address and just get a PO box for this type of thing.
Who's Carolyn Joy?
She's my mother.
Your mother has a PO box, correct?
True.
That's information on one of these forms.
Maybe it was sent to her.
the planning department's denial letter dated September 7th in this matter, did you receive it in the mail?
Yes. I am picking up some mail there.
Okay. So, just kind of bringing it back, if no commissioners have any further questions.
Correct.
Okay. We're going to go ahead and close public hearing. There's no
Okay.
public comment. Rebuttal's done, so we're going to bring it back for deliberation.
Okay.
So I can start with the ordinance states that you have to keep a current, correct address, period. Doesn't matter. We got to be able to contact you. The denials went out. I guess for me, part of the confusion comes in with he hired a company that evaluated his property wrong. He brings proof that it needed to be reevaluated, and they changed their evaluation. Did we ever have proof of Tier 1 from this company the first time around, or were we just told they did it?
We have a copy of that original tier assessment that was done.
And they did do Tier 1 on the first time
Yes,
around?
ma'am, they did. That is correct.
Okay.
The first notice of intent was
The,
sent in before September 7th or whatever?
correct, yes, it met the September 7th deadline, and he was given a site assessment by what I think the average person would assume was a reliable professional for the Tier 1 filing, enrollment. So that's what he did filing. However, he was informed fairly promptly that that was incorrect.
And Ed, do you know, if you submit something by September 7th, 2016, how backed up is the water board? Would it be rare that they not ever say, yes, you've made it? Or what do they do when they agree with what you've sent in? Do they send some sort of approval, congratulations? And how soon might somebody expect that?
Well, ultimately, what we're waiting for is a notice of applicability, and that may
Okay.
take several months for them to get to that point. So it wouldn't be unusual for them to, send out their first notice of the NOI being non-applicable, a month or two or three down the road, just like.
Well,
we could
here it
expect-
was 8 months down the road.
It was November, I believe.
Oh, of November, I'm sorry.
It was
Yes.
November.
And
which
then it was 8
September.
months
That's
after
2
that.
months later.
Yeah.
And then, from there out to July, that's another
8 months.
8 months. I mean, it's, and that's just their follow-up with the second, but the initial one was, within 2 months of that deadline.
But if they had, I guess, would they have done all their evaluations as of that point? I mean, if he were going to be accepted?
I don't have knowledge
You know,
of that.
okay.
Yeah, most likely at the time that they would have determined that it was either the inaccurate tier. If it had been correct, they probably would have issued the notice of applicability, which is the permit.
At about the same time.
At about the same time, unless there was some other thing that was missing. But once they've done that analysis, it's, okay, this is good, we'll issue the NOA.
So for me, it's difficult because we've got some conflicting stuff here. For me, it's like you hire someone to do their job, they messed up, they're responsible for this. They made the mistake, not us. The September 7th deadline is real. And when they mail you notice and you don't get it because that's not the address, you're picking up your mail, or you're not updating the county and saying, I'm not getting my mail here anymore, it's over here. It's in the ordinance that needs to stay current. I have an issue with that. I believe that we've got a lot of these addresses there's too many different ones being used on different documents, and that doesn't show any consistency in regard to the urgency ordinance in keeping your information current. I don't know how, what the rest of you are thinking, but I'm really struggling with this one as far as that there was no follow-through, and there should have been. Do
Kind
we, I'm sorry?
Kind of, because there was some follow-through. If you would have given us these set of papers, I'd give him, he might not have got the first letter that was received the first in November. But the other one was sent 8 months later. I have a hard time believing he didn't receive both of them. But after seeing these are not the only ones he received. In my opinion, he got them on the other properties. Otherwise, why is he filing for 3 different ones? These are 3 different applications, 3 different payments, all made and a couple days ago.
Well, his explanation, I think, was he came down here and found out problems with the other 2 properties.
Right, I
He got
agree with that,
one.
but that means that there was 2 letters for each property. That means he didn't receive 6. That's where I'm kind of, no, I agree that he probably didn't receive one of them. He might not have received 2 of them. What happened to the other 4? When he came down here for a denial for the other property, and then he found out he was denied on all of them. And so there's a total, it sounds like 6 letters, and he's the one who brought that evidence to us.
Well, I do think we have, at this time, there is no better address. It's just that it's been very sloppily handled, either intentionally or, I mean, not intentionally, but I mean, there hasn't been great care given as to what mail has been received at the official address. It's not that he's moved or that some other address would be better. He hasn't established any better address, so I think we've got 2700 Railroad Flat Road as the address. Then I think we get to credibility. I mean, I think as he claims, that once he became aware of the denials, he immediately took steps to submit something on Tier 2, which he has. I mean, in contrast to an earlier applicant where he was waiting to make the payment and go through those.
Except the Water Quality Control Board on previous ones always issues something to our county saying, hey, we've received all of this and we're continuing to process it. They won't give us that. What Paul has stated is that they've said to him, they're going to wait to see what the Planning Commission decides before they issue anything on this. On the other ones, the Water Board was willing to issue. On this one, they're not. Why?
Well, I mean, we're getting into the chicken and egg on this sort of thing, where we're saying, oh, we'll wait for the Water Board, and they're saying, we'll wait for the county. I think we just look to the facts of this case.
That is the facts.
Well, I don't take from that they suspect that he hasn't done something right.
We could clarify that.
Please.
The reason the Water Board would not grant a notice of applicability to him is if it was unlawful for him to cultivate in this jurisdiction. If you grant this appeal, he gets it. They're waiting for you to let him continue to grow. He's done all of his paperwork.
So, and you think that they recognize that he's done all the paperwork
Yeah.
that's needed, and
So,
and I think one thing we have to keep in mind, that it is important that this land have the protection that the Water Quality Control Board will give to it with its regulation. I think a result of denial could lead to, it would obviously lead to the Water Board not taking any action. And I think right now, given the funds for regulation and such in this county, it's great that the Water Board is there doing whatever protection it can. I would not say that would forgive if Mr. Houghton had received them and just decided he wasn't going to do anything about it. That wouldn't get him off the hook. But I believe that he officially received them at the mailing address that he gave, but I believe that he never saw these. And on that basis, I find it a very hard one, but I think given all this good faith activity since he heard about these appeals, tends to indicate that, yes, he's indeed was telling the truth, that he wasn't aware of these 2, 4, or 6 denial letters. So I'm ready to give him the benefit of the doubt so that the land can get the benefit of the water board.
And I have a similar approach. I do think Mr. Houghton's approach, or Mr. Houghton's situation, is a stronger case as to the water board forms. I think that's, council's just told us. It's not a matter of Mr. Houghton holding back and waiting to see how the Board of Supervisors decides or something like that. He's actually submitted the documents, and the water board says, fine, as soon as we approve it, it's done. So I think that's actually a stronger situation than the one we ruled on earlier today. It's a little odd, maybe it's very odd as to these addresses and not getting them, but it does seem that he responded once he got the information, somewhat confusedly, and I hope he do get these straightened out no matter what, but I'm going to go ahead and uphold his appeal.
You waiting for me?
Yes, sir.
I think this is a difficult one. And I agree with the comments that it's fairly clear that when Mr. Houghton learned that he had a major problem in September of this year, he moved quickly to fix it. Where I'm having a real difficulty is that he submitted his paperwork in September a year ago and apparently heard nothing at all until a year later. And that's a long time to sit and wait and wonder what the water board's doing. And it seems to me that the water board sent these notices to the only address they had. And if it didn't get picked up twice, I think that problem lies with the applicant on his end. And it should have been picked up. Once I could see maybe got lost or whatever, but twice I don't think so. I think it probably did get there in the mail and nobody got it. And that's not the water board's fault or the county's fault. That's the applicant's fault. So I think that this has just gone on way, way too long. I'm tentatively inclined to deny the appeal.
So I guess for me, it boils down to keeping your records current, picking up your mail. The applicant did not receive, as Commissioner Sisk has pointed out, 6 letters, but the first denial letter that came through, he acted quickly and found out about his other grows. So it's, you know, I have to say, if I looked at, and where is it? The letter from the water board. Don't we have one of those? Did we get a letter from the water board?
Just the notices.
Okay, where's that? Well, I can see,
Well, there's the one in the file, attachment 4.
so I'm going to tell you where the problem lies right now. He never did get the letters from the water board, ever. His address from the water board has the wrong zip code compared to everything else. The water board does not have the correct address.
The right one is consistent with what we have
It's
on our...
consistent on that, when you put it on the application.
It's 95246 on here. What's it on there?
245.
245. So, and the county's address is what? We have 95245. So he gets that. What is your zip code?
It's the right way.
Who typed this letter? Your name's spelled wrong. The mailing address is wrong. The zip code is, I'm sorry?
I did it.
Okay, so now we
The
have,
September 16th application gives 95246. But it is 45 where you live. Okay.
So the water board did the right thing even though the application was incorrect.
They corrected it when they sent out their letter.
While you're checking that, I do think one of the important things is getting water board coverage. They're ready to grant coverage for this. I share your concerns about the attention that he gave to his mail. I mean, I think it's remarkable that these two notices went unchecked. But as far as we know, everything else is valid as to this grow, and with our approval, it will have Water Quality Control Board supervision and regulation. That in itself isn't enough. I have to recognize that Mr. Houghton's telling the truth. It's a very unfortunate truth. But once I get to that, and given the coverage of the Water Quality Control Board, I think the right decision here is to grant the appeal.
I'm going to uphold the planning departments. I think there's just too much here. I think that if my livelihood was staked on this, my phone numbers, my addresses would be first and top priority. I'm reading this and I'm stunned, and I see it's handwritten, the application, the zip code's wrong. I don't even get it. I'm sorry. I just think that if it were me, I would have been a lot more cautious, and the urgency ordinance does cover taking care of your notification addresses in a timely fashion. And I just find it's just too hard for me to conceive that you can not get 6 letters, but you can get 1. And that 1 letter brought him in to cure all his other problems. And do they all have problems? I don't know. And if it just 4 or 5, again, it's different. Okay, so I guess that's where I'm at. So we need to make a decision what direction we're going in, if we're going to have the recommendation here that's in front of us read and vote.
That's what I want.
Okay, so if we're going to do that, there are some changes that need to be corrected on it. I know he wasn't notified November 3rd, 2013. If we could just make that November 3rd, 2016.
Where are we at?
I'm under the evidence on page 2 of 2. What? Sure, we can vote.
Oh,
Okay, so if somebody would like to, you can read the recommendation first, please.
very good. Staff recommends that the Planning Commission adopt Resolution 2017-085 denying Appeal 2016-545, thereby upholding the Planning Director's determination to reject Appeal 2016-545.
Thank you. Get a motion?
So
Second?
Second.
All in favor, state by saying aye. Aye.
Aye.
Opposed?
No.
Motion carries 3-2.
This action is final unless appealed to the Board of Supervisors within 15 calendar days.
Okay. Next is... No, what Peter was just telling you is you'd have to file an appeal and take it to the supervisors now. Absolutely, you can have counsel represent you. You can go over to, well, the planning department's closed now, so, but you can,
Talk to him about that.
oh, he's gonna take you outside and talk.
Copies of-
His copies are where?
right here.
Okay, so next on the agenda is going to be informational items, and there are none. There are no study sessions. And do the commissioners have anything that they would like to report out on or discuss?
Then we're going to have a planning director's report, right?
Yes, after we get done.
Yeah. Nope.
You have nothing to report? There's nothing happening in your districts that's exciting and...
Nothing.
Stop it.
How would we're here all the time?
What?
I
Should
said,
they turn the stoplight on?
They turned a stoplight on?
Oh, they're going to. That's not what I went through this morning.
Okay. Okay, so then, if that's it, I guess we go to the planning director reports.
Okay, I have two items I'd like to discuss. The first one, we've been advised by IT, or tech services, that you need to use the county email.
I've been checking it.
There's issues associated with Public Records Act, as well as just security for the email system. So for all county work, you need to use the county email system. If someone needs help in how to access that, let me know, and we'll get someone to help. I'm not the person to ask, but there's someone that can do that for you. Okay. Yeah, so it just, there's been some issues associated with, and the real concern for you would be that any documents that are sent on your private email essentially opens up that for all kinds of discovery. We don't want that.
So do we want to have IT come in to show everybody at once how to do it? Or should we have
What would
one-on-one
be easiest for you?
assistance?
To have someone come in at the next meeting to say this is how to do it? We can put it up on the screen and sort of walk you through it?
I'm good with it. I think
Or
that-
do you just want to come into the office and we can show you how to do
I
it?
think they should go in so that people, it's not publicly going out there how to log into the county server. We've already been hacked once.
Probably a good idea. So let me know and I'll coordinate something with the folks that can help you.
Yeah, they could probably do it over the phone. Right?
No.
Possibly. We could try that, and if still you need, I'm a visual learner, so I need to see it to understand it, so it depends on how you learn.
Now, does this apply to both receiving messages and sending them?
Yes.
So it's real simple, just so I can give you all, and I know, so here, all they're going to do is give you a link that you're going to go onto your internet with. You're going to put in your username and password and log in. That's it. And then there's all your emails. And it's no different than using your email you currently use. You hit reply, read, send. It's that simple. So it's just a link, a username and password.
And you could save it on
Is it any better than Target Solutions? Am I
I-
the only one having problems with that?
Apparently
Target
so.
Solutions.
No, you're
It
not.
doesn't
Target's-
work on my computer.
Target
I
Solutions.
have 3 of them.
If you, you can't use your other password for any other
I haven't gotten
organization.
that far. They've never
Okay.
emailed me anything.
Okay.
You're not the only one, Commissioner Bacilli.
And I've checked spam, it's not spam.
Contact me.
Same here.
My dump file.
Okay, so if the 3 gentlemen here, maybe Annette can send them, or a Stan can send you an email, or you guys can get a phone number to call him and set up an individual appointment. Maybe one day we'll have a super short meeting and you can come in after or before the meeting and meet with him. Because I think he's here at 8 and we don't start till 9. So it'll take all of 10 minutes to show you guys how to do this.
Who is the person we need to contact?
Let me find out and I'll let you know. I will call you
When I
and
have
let you know.
problems, I just called Human Resources and they connected me with whoever.
Yeah, HR, well, it's probably someone in IT. Stan Moore is the director, but I'm not sure the director needs to do it. I'm sure there's any number of staff people that can show you how to do it.
And then you can contact, if there's issues after you're taught, you can contact IT and they can show you one-on-one how to do it.
Okay. Sounds like a great idea, it's just that we're gonna have to conscientiously
Yeah.
go into the website.
You have to go to the county website first.
No.
No.
We'll find out.
No, you can log in from your own computer, just like going to a different,
Yeah, you go to the website.
Well, we'll find out. Well, that's what we're gonna be taught.
Take 10
He's,
seconds.
he's not the guy to teach us, he's told us.
I'm
It
definitely
is
not
not
the
the
guy.
county website.
Yeah.
It is a specific website addressed for email.
Oh, so send it to me.
That's right.
Did they give it to you with the
Probably, it gave me a lot of.
I bet your wife could figure it out for you.
Well, and that's, wait.
Not getting that credit.
I also, and one of the issues that has come up, I probably should address this, is there are people who have shared email at home with their spouses, and attorney-client communications need to be confidential. There are times where you all will be receiving confidential information, so we can't, part of the purpose of this is to not have that shared
Yeah.
link.
No, that sounds like a great idea. It just
Okay.
complicates things in some ways, but might make life a lot simpler down the line.
Yes.
So, no complaint. I would appreciate getting your reading about, the cannabis one.
That was next. Saving that for last. So, I'm sure everyone's heard, we had the direction from the board on Tuesday to adopt a regulatory ordinance with, so starting from your recommendation, but additional criteria. So we've been directed to draft that. Julie and I will be working on that over the next several weeks, and then to bring that back to you for a review and recommendation to the board.
And I noticed that the motion was to take into consideration Supervisor Tuffanelli's list.
Yes.
So, right, and so I will be drafting to Supervisor Tofinelli's list. I think there's been some confusion about whether the direction is that the Planning Commission is not allowed to make recommendations. Otherwise, I've spoken with Supervisor Tofinelli, I've spoken with the County Council, and there's nothing that prevents the Planning Commission from continuing to make whatever recommendations it wants, yea or nay. The board will choose to listen or not listen, as they have been already doing. And so I think, I'll draft the regulation to those recommendations, and then you can discuss what policies or what language you're okay with or not okay with. And I don't think that the board, my understanding is that the board will not be, that that's acceptable. They just are not obligated to follow your recommendations.
Right, but you're basically now going to put in ordinance form what we suggested plus
Right.
Supervisor Tuffanelli's.
Right, and Supervisor Tofinelli clarified, because I asked this question at the hearing, I said, to the extent that you didn't mention any of the things that the Planning Commission recommended, if that wasn't included in the list of bullet points that you've just provided, I specifically asked if he wanted that to be then ignored, or what, and he basically said no, he wants everything that doesn't conflict with his bullet points to be included in the ordinance. So he's not rejecting the Planning Commission's recommendations.
For our purposes, it would be, make our life a lot easier if, since you're going through this and seeing where there are conflicts, if you could put in a note, footnote,
Sure.
parentheses or whatever, saying this conflicted with the board's, the Planning Commission's recommendation that such and such.
I will put where I see conflicts, and it's up
Yeah.
to you whether you agree
Right.
that there's
No,
a conflict.
No, that would be very helpful.
Okay.
And I don't envy your job at all, but that would,
Okay.
that would be good. Is there a possibility for the sheriff to have input at this stage?
Well, the sheriff has said that he has some things that he wants to see in there, and I am happy to meet with him to see if he has recommendations that are sort of in line with what the Planning Commission and Supervisor Tuffanelli have already recommended. I don't feel it would be appropriate, given that I take my direction from the board, to change anything or modify outside of the general direction I received from you and from the board. But that doesn't mean he can't come to the Planning Commission or submit to the Planning Commission additional language he wants to see. To the extent he has language that's sort of just more detail, that follows in,
It's
with things that have already
consistent.
been recommended, such as background check language, et cetera, then I will put it in there. But I certainly will invite him to, he should understand that anything I don't put in that he says is not because I feel it's necessarily illegal, but it's a little difficult because he's coming after the fact with additional recommendations. So we will make sure that his recommendations make it to the commission. We might have to modify, if to the extent you want to adopt them, we might have to further modify the language of the ordinance.
There were some things that I think weren't entirely clear to the Board of Supervisors, and one was that we indicated that property that's currently unclassified could become eligible for the grow if they had a change in zoning. And I did from.
I don't know that it wasn't clear. They didn't discuss it. They
Well,
did not discuss our recommendation at all. They discussed,
Well, the reason I say that, and I was trying to be circumspect, is that I saw Peter's bullet points, and it seemed to just, it said, these are the ones, the types of zoning that will be permitted. And I don't think it mentioned unclassified. Your end result is what you said, but
Well, I don't think that the potential to rezone property was limited to unclassified.
yeah.
right,
If you had another piece of property, it was zoned, say, RR, and someone wanted to apply for a zone change to A1, they had the right to do that. So we didn't specify unclassified, but that's clearly one that currently there are a large number of applications either been approved or pending that would not qualify under the ordinance unless they were rezoned.
And I have to caution, we don't have an agendized item right now on interpreting the board's direction. So
Right, right.
I think that, you know, I've explained what I intend to do, and the commission can always recommend changes to the extent it thinks that the direction was different or has additional recommendations for the
And I
board.
would suggest that we build into the process, I know this is going to probably be another meeting then, that we have a chance to massage what you come up with and then see the end product that's going to the Board of Supervisors.
How do you know it won't be perfect?
I don't know that it won't be perfect.
So on that, we only have one regularly scheduled. We have the special hearing on the 2nd for cannabis appeals. We have a regular meeting on the 9th. We will not be able to get anything to you before then. The second meeting of November is always usurped by Thanksgiving. So there is a possibility we could schedule a special meeting, you know, one of the other weeks. Now, Julie has a lot on her plate. We both do. It's going to take some effort to try to put this together and give everyone plenty of time to review it. The only real day that we have in the last week of November is Wednesday, the 29th. Now, there's an outside possibility, and I cannot guarantee this at all, that we might have something available earlier, that we could meet the week before Thanksgiving, but that's a real push.
And please don't count on that.
Yeah.
I have some pending litigation, and depending on if it goes away or not, I might be able to be quicker, but I can't.
But
So what I want to do right now is just try to identify potential available dates that we might hold a special hearing just for reviewing that. Otherwise, we're looking into December, and then December gets crazy with the holidays and trying to make sure that the board has a chance to review your recommendation to them and adopt something in December.
Thursday, the 30th is not available, is that? if I understand?
Unfortunately, I'll be speaking at a conference, I
Well,
think.
I'm very
Doesn't-
pleased to hear it because I changed my,
it doesn't have
Doctor's
to be a
appointment,
Thursday, correct?
It does not have to be a
Doesn't-
Thursday.
Okay. So-
Okay, so we could go the week following Thanksgiving, which could put us at the Board of Supes' Tuesday. We could go Wednesday, the 29th, if that would work for everybody.
that would not, I mean, if we're looking, at the board looking at it the next Tuesday, I'd like to see the final product that's going to the board.
Well, you know, if
What I was saying
we
before.
end up drafting an ordinance and there are significant changes at the point that we need to bring it back to you for final adoption, we'll just have to do that.
Yeah, okay.
And you have the right to not take final action if you're not ready for that.
That's fine.
The state law says that you need to report on the legislative acts to the board, and the board can say you've had enough time and just take it from you if you haven't, but there's a time frame to do that. And I think that we're all anxious to get it done as quickly as we can, but we have to look within the, reasonable constraints of human possibility, capability.
Well, I don't know that we need to have a second meeting. I think that over the years, it's been proven that when we give direction, it goes back correctly. I have never seen it go back wrong. But if you're going to get a copy of it, the entire public's going to get a copy of it to review it. And if there's something in there you don't like, show up with the supervisors and tell them.
All right.
That we can't delay. We cannot, well, no, yeah, I guess we can. We are right
Well,
now.
the urgency ordinance does expire
Oh, no, no,
in February.
I'm fully aware of that, and I'd be happy to have a meeting the next day, but not that next day, I guess. My smartphone died a few weeks ago, so I don't have a calendar with me. I think the 29th is okay, but I'd have to let you know by email.
They have paper ones too, I always.
Yeah, I know,
have
my
both.
wife has that one.
How does the 29th look for everybody else?
Okay.
I'll make it work.
Are you around?
I'll figure it to next, because the week, the 13th, I'm really worried about it.
So that week works for you?
We gotta try next.
Okay.
Without you having to cancel Hawaii.
I'm not available on the 16th. I have a haircut
Okay.
in Concord.
You what? I'm sorry?
I'm sorry, my wife's got to this.
Oh.
Okay.
But Karen, you're out the week of the 13th, so if we have something earlier, it doesn't really matter because you won't be here.
I
So
don't like to discuss dates.
I would like to go on vacation.
So the 16th, you won't be here, is that correct?
I plan on not being here.
Okay.
not available.
Not available.
And I unfortunately turned off the calendar prematurely, so I can't check the availability of the room. But I can check tomorrow morning.
Okay.
I've got a couple questions about this. The planning commission already considered this issue and made its recommendations. Is there any legal necessity for the planning commission to revisit this issue as opposed to the county council drafting the ordinance that apparently a majority of the board suggested wants, giving it to the board and them acting on it?
Other than the fact that the board directed us to bring it back to you. They want you to vet the language, which you guys are very good at.
They want you guys to do the work.
That was part of the direction.
So the answer is, they could have simply said,
Bring it back to us.
county council, write this thing up and bring it back to us, not bother the planning commission. Legally, they could have done that.
They could have done that, yes.
Okay, second question. Having sent it back to the planning commission, would it not be true that the commission has to hold a public hearing on this matter?
I'm sorry, say that again?
Our next meeting will be on this issue, a public
It will
hearing
be a public hearing.
Yes.
with opportunities for public comment and everything that we did before.
Right. I do want to clarify that.
Groundhog
I would feel, in terms of whether it has to come back to the planning commission in the actual form of an ordinance, I feel like I haven't done research on the government code to know, I know there's rules that if you have a planning commission, certain things need to be done. I don't know whether it is required. I feel like I would need to research and look that statute up and get back to you on whether or not it's mandatory for the ordinance to be an ordinance form, or whether the bullet point list would have been good enough. That I'm not sure. But the board's direction, I didn't look at it because the board's direction was to bring it back. So I don't want to give you the impression that I'm 100% sure on whether it was good enough to not actually have the ordinance.
I think on
So-
this issue, I think it's important that we see the ordinance as an ordinance.
I think that we have a future scheduled meeting to discuss this, and at that time, we'll make decisions, but right now, this is not an agendized item, so the only thing that I think that staff was looking for was a date we could have a public meeting to discuss the item. And let's leave it at that. We're all looking at the 29th of November.
Okay.
Thank you.
And if we're going to go through a bunch of public hearing and this sort of thing, start it as, oh, you don't have Rotary on Wednesday, do you? Start it as early as we can and reserve the room for as late as possible.
Careful.
Now, that's-
Okay, we can't start it as early as we can because his wife has set our times for us. 9 a.m.
Well, the last time we set aside 2 days.
Yeah,
I don't think we
Do we
need
have
2
the
days, do
29th
you?
and-
But the last time we set aside 2 days because one was for the.
Dispensary
Dispensary.
and Prop 64.
and getting the ban, now I'm assuming the personal use provisions from the ban ordinance will be in this ordinance, or is it going to be a separate ordinance?
No, it'll be.
We will have all the
It'll
provisions.
be in
yeah.
there.
Because it-
Yeah,
yeah.
I think that you know, the fundamental decision of what the board wants and what you had recommended, we've been through that. Now, that's not going to prevent the public from saying, you guys are all wrong, you need to do this instead. But I think that the internal discussion of what direction should we go has been resolved by the board. And so now it's a matter of, does this ordinance meet the criteria that we think, given that overall direction?
Well, I thought I heard earlier that we had the discretion to come up with whatever recommendation we thought was appropriate.
I think you do.
Well,
All right,
and
now-
as I was saying that, I said, well, maybe you know,
I think
you could
you do.
still make a recommendation that we'd like the ban ordinance that had been prepared a month ago.
Well, I intend to speak to that, actually. I'm not going to sit here and be a proofreader for the Board of Supervisors.
Okay, so again, I don't know if you want to agendize a discussion on interpreting the direction prior to our special meeting, we could possibly agendize that. That might be a long meeting, but I'm concerned about getting outside of the Brown Act by going too far on this.
No, I'm done.
Okay.
Okay, so we have tentatively scheduled a meeting for Wednesday, November 29th. Annette is going to check the schedule. There is the possibility that day could change if Julie's schedule allowed for it. Nobody should count on that. So at this point in time, Annette will send us all an email confirming date and time, probably later tomorrow.
If it's gonna be earlier, I need to know as soon as possible, just so you can put tonight.
Okay.
Could you get
No, I don't think that's
We're
going
not,
to
I
happen.
don't think we would set it earlier if you're not going to be available.
Okay. So, on that note, thank you all for a great day. You were well behaved and wonderful. Thank you. Thank you.